Hello, my name is Jim Dunn. I'm a family lawyer in Canberra. I've practiced for some 30 years. I now consider myself as a collaborative family lawyer. I'd like to talk to you today about collaboration and difficult cases. Sometimes people think that you can only use collaboration for the easy cases, for those cases in which people want to cooperate, want to be fair to each other, have nearly reached an agreement. If that's the case, then it will make it quicker and easier, but in my view, it's not necessary. I'm confident that the collaborative process can work when you're worried about money being hidden or assets disappearing. And it can even work where there is deep anger and mistrust. So how will collaborative law deal with the worry about hidden assets? It is really quite simple. Early on in the collaborative process, we sit down. We understand, firstly, my client's worries, that money's been disappearing. We then get the documents out, and I have the ability right at the beginning to ask questions, for you to ask questions, to really look at what's been happening and to understand it and have it explained. In the traditional system, we have to write documents and wait for the court for 1 or 2 years. It's a difficult process which really doesn't work. The collaboration process enables this to come right up front at the beginning. So the question that I'd like to answer is, how does the collaborative process deal with hidden assets or money? The way we do it is through the four-way meeting. At the four-way meeting, we sit down with the documents and I can ask questions. And very soon, the concerns that you have are talked about, and then I get the ability to look at documents, to ask questions. Very quickly, the things which looked deceitful quite often evaporate. It is a very powerful tool. One of the questions my clients often ask me is, how can collaboration work, which involves honesty, if they don't believe their former spouse is honest? My answer is this: very soon in the process, I get the ability to sit opposite their former spouse, ask them questions, look at documents. It's a much more open process. I know what's happening. In the traditional process, their spouse is locked away in a room with their other lawyer, and I never see them until 1 or 2 years down the track at a final hearing. Sometimes my clients tell me that they couldn't face the collaborative process. They're too anxious, they're too angry, they don't want to face him. And in other cases, there was violence and they don't want to face their former spouse. I can understand these worries and concerns, but again, my view is that the collaborative process addresses these in a much more efficient and safe way than the traditional legal process. In those collaborative cases where the emotions are extremely high and they're getting in the way of progress, we're able to call in psychologists. Those psychologists can come into the meeting if need be, or talk to the parties outside. There is just an infinite number of ways we can deal with that. This type of thing just is not available in the normal litigation model. Another advantage of collaborative law that I've seen over the years that I've been practicing it is the ability for either party to really put their cards on the table. There are sometimes issues which are causing emotional hurt or getting in the way of a settlement that in traditional law you can't talk about. In collaborative law, we can put it on the table. Sometimes an apology for a past hurt is all that's standing in the way of a settlement. Most of all, I recommend the collaborative process to you because all who are involved are trying to get a situation where there is a win-win. In the traditional system, where there is rights-based, a victory by one means a loss by the other. I really recommend this process to you.